morning to everyone in and around this courtroom. Madam Magistrate, would you please call the case?
Good morning, Your Honours. Good morning, everyone in and around the courtroom. This is the case ID 03690, the prosecutor versus Jovica Stanišić and Franco Simatović.
Thank you, Madam Magistrate. Before the Chamber will deliver its decision today, I first address you, Mr. Stanišić. We received a request from Mr. Jordaš to be allowed not to be present today, and to be represented by other members of the team. Now, the Chamber has some formal difficulties in allowing representation by not yet assigned counsel. First of all, do you agree to be unrepresented today?
Your Honor, I do agree.
Then the Chamber establishes that Mr. Scott and Ms. Verwiel are present in court, so if there would be any need to communicate with counsel not being present, that you have a possibility to do so, just address me. Second, it's also on the basis of the character of today's session, which is limited, as a matter of fact, as far as matters stand now, to issuing a decision on an oral motion for acquittal by the Simatović defense, that under those circumstances and with the agreement of Mr. Stanišić, the Chamber accepts the accused, Mr. Stanišić, not to be represented, although not being alone today in court.
Thank you, Your Honor.
Then I move to the main subject of today's session, that is the delivery of a decision on the Simatović defense's oral motion for acquittal pursuant to Rule 98 bis. As I said, the Chamber will now deliver its decision on the Simatović defense's oral motion for acquittal pursuant to Rule 98 bis. The Chamber notes at the outset that the Stanišić defense did not present any Rule 98 bis submissions. The decision of the Chamber, therefore, relates only to the accused, Franco Simatović. However, given the alleged roles and participation of the two accused within the joint criminal enterprise, or JCE, charged in the indictment, and the close relationship said by the prosecution to exist between the accused, the Chamber will at times during its decision necessarily refer to evidence relating to Jovica Stanišić. The Chamber heard oral submissions from the Simatović defense on the 7th of April 2011 and submissions in response from the prosecution on the 11th of April 2011. In reaching its decision, the Chamber has considered all submissions of the Simatović defense and the prosecution. The Chamber will first give a brief summary of those submissions. The Simatović defense requested the Chamber to acquit the accused Franco Simatović on all counts of the indictment. Its submissions may be found at transcript pages 11,300 up to 11,353. The defense argued that the prosecution had failed to provide evidence showing that there was a plurality of persons working together with a common objective, and that Mr. Simatović was one of those persons. According to the defense, the prosecution had also failed to show that there was a common objective amongst the alleged participants of the JCE. It had also failed to prove the intent of any of the alleged participants of the alleged JCE, and that Mr. Simatović would have shared that intent. In relation to the alleged participation and knowledge of Simatović, the defense argued that the prosecution had not presented, and I quote, any concrete evidence about the acts or omissions on the part of Simatović in the context of the allegations contained in the indictment. End of quote. Further, it submitted that there was no proof that Simatović knew of any crimes charged in the indictment. In relation to the role of the Serbian State Security Service or the Serbian DB in the establishment of special units, including the Scorpions and Argenstigers, the defense submitted that there was no proof that these units at any point in time relevant to the indictment were under the control of the DB of the Republic of Serbia. The defense clarified in court on the 12th of April that by no proof it meant that the prosecution had not provided any proof which, even if it were to be assessed in the most favorable light, could lead to a conviction. The prosecution submitted that the Simatović defense's motion for acquittal must fail. Its submissions may be found at transcript pages 11,355 up to and including 11,436. The prosecution submitted that it had presented relevant, probative, and consistent evidence in support of each count in the indictment, and that it had met its burden at this stage of the proceedings. Throughout its response, the prosecution drew the Chamber's attention to particular evidence that, it submitted, demonstrated the existence of the alleged JCE and the significant contributions made to the JCE by the accused Simatović. In doing so, it also sought to highlight the close relationship between Mr. Stanišić and Mr. Simatović, and submitted that the two accused, and I quote, must have shared knowledge and discussed plans and functioned as a single cohesive unit. Rule 98 bis of the Tribunal's Rules of Procedure and Evidence provides as follows, and I quote, at the close of the prosecutor's case, the trial chamber shall, by oral decision and after hearing the oral submissions of the parties, enter a judgment of acquittal on any count if there is no evidence capable of supporting a conviction. End of quote. Under the case law of the Tribunal, the Chamber must examine whether there is evidence upon which a reasonable trier of fact could be satisfied beyond a reasonable doubt of the guilt of the accused. Thus, if a reasonable chamber could be satisfied beyond a reasonable doubt of the guilt of an accused on the basis of the evidence adduced in relation to a count, then the count must stand. There must be sufficient evidence for each element of the alleged crimes and for one of the modes of liability contained in the indictment. The test would not be satisfied if there were no evidence. If the prosecution has presented evidence, that evidence is entitled to credence unless incapable of belief. At this stage, the evidence should be taken at its highest for the prosecution. The Chamber therefore will not concern itself with issues of credibility or reliability unless a witness is so lacking in credibility and reliability that no reasonable chamber could find him or her credible or reliable. The Chamber will now provide a summary of relevant parts of the indictment. The indictment covers 5 counts of crimes allegedly committed from at least the 1st of April 1991 to the 31st of December 1995. The areas covered by the indictment include the Serb autonomous region of Slavonia, Baranja and Western Srem, or SAO SPWS, both in Croatia, and The areas covered by the indictment include the Serb autonomous region of Krajina, or SAO Krajina, and the Serb autonomous region of Slavonia, Baranja and Western Srem, or SAO SPWS, both in Croatia, and the following municipalities in Bosnia-Herzegovina: Bijeljina, Bosanski Samac, Doboj, Sanski Most, Trnovo, and Zvornik. According to the indictment, Mr. Simatović worked in various positions within the Serbian DB and was the commander of the Special Operations Unit of the DB during the indictment period under the authority of Mr. Stanišić. The first count of the indictment charges persecutions as a crime against humanity. The second and third counts respectively charge murder as a crime against humanity and as a violation of the laws or customs of war as recognized by Common Article 3(1)(a) of the Geneva Conventions of 1949. The final 2 counts respectively charge deportation and the inhumane act of forcible transfer as crimes against humanity. The indictment alleges that the accused and others participated in a JCE, the objective of which was the forcible and permanent removal of the majority of non-Serbs, principally Croats, Bosnian Muslims and Bosnian Croats, from large areas of Croatia and Bosnia-Herzegovina. This objective was allegedly carried out through the commission of crimes charged in counts 1 through 5. According to the indictment, the accused's participation in the JCE included directing and organizing the financing, training, logistical support, and other substantial assistance or support to special units of the Republic of Serbia, DB, and other Serb forces which were involved in the commission of crimes in Croatia and Bosnia and Herzegovina during the indictment period. The indictment further charges the accused by his acts and omissions with criminal responsibility for having planned, ordered, and/or otherwise aided and abetted in the planning, preparation, and/or execution of these crimes. In its legal characterizations, the Chamber adopts and applies the Tribunal's consistent case law with respect to the definition of the elements of the crimes and modes of liability charged in this case. In this decision, the Chamber will address the law more specifically only when this is required, to explain the Chamber's findings. The volume of evidence before the Chamber and the character of the 98 bis proceedings do not allow for a comprehensive discussion of the evidence in this decision. The Chamber has, however, considered the evidence in its entirety. The specific evidence that the Chamber will refer to in this decision is therefore merely a selection of what the Chamber has considered. In relation to the crimes charged, the Chamber has verified whether the evidence addresses all the elements of each of the crimes. Similarly, the Chamber has verified whether the evidence addresses all the requirements for criminal responsibility as charged for the accused Simatović. Finally, in relation to each crime charged, the Chamber has verified whether the evidence, taken at its highest for the prosecution, could lead a reasonable trier of fact to conclude, beyond a reasonable doubt, both that the crime has been committed and that the accused Simatović bears criminal responsibility for it. The Chamber will first examine the crime base as alleged in counts 1 through 5 and determine whether there is sufficient evidence with regard to each of the elements of the crimes to conclude that the counts in that respect should stand. The Chamber will then turn to the question of the individual criminal responsibility of the accused Simatović. The Chamber now turns to the general elements and jurisdictional requirements that must be proven under Articles 3 and 5 of the Statute of the Tribunal. The defense did not challenge these elements in its Rule 98 bis submissions. The Chamber notes that the prosecution alleges in the indictment that at all times relevant to the indictment, a state of armed conflict existed in Croatia and Bosnia-Herzegovina. Based on the Chamber's review of the material before it, the Chamber considers that it supports the prosecution's claim that an armed conflict existed at the times relevant to the indictment. In examining the general elements of violations of the laws or customs of war, the Chamber has considered various incidents of murder. It will address this evidence shortly when discussing each count of the indictment. The Chamber considers that the evidence before it, including the mentioned examples, indicates that the victims of these crimes were not taking active part in hostilities at the time of the offense, at the time the offences were committed, and that the murders were closely related to the armed conflict. Similarly, in examining the general elements of crimes against humanity, the Chamber has considered incidents of alleged murder, deportation, and forcible transfer. This evidence will also be addressed below. The evidence before the Chamber in relation to the nature and the number of these incidents, as well as the numbers of persons targeted and their age and ethnicity, indicates that these incidents were part of a widespread and systematic attack on the civilian populations of the areas specified in the indictment, and that the perpetrators must have known that their acts were part of such an attack. The chapeau requirements of Articles 3 and 5 are thus met. The Chamber will now turn to an examination of the individual counts in the indictment. In relation to counts 2 and 3, there is evidence of murders taking place during the indictment period and within the indictment areas. For example, with regard to the SAO Krajina, witness Ante Marinović, a Croat from the Marinovici hamlet of Bruška, testified that on the evening of the 21st of December 1991, he was home with his father, his brother, his uncle and a Serb neighbor named Sveto Drača. They were playing cards. At about 8 or 8:30 p.m., 3 soldiers wearing camouflage uniforms with Krajina militia insignias entered the house and told the men to get up and to go outside. The soldiers lined the men up against the wall on the outside of the house. The soldiers shot the witness, his father, and his brother. Having fallen unconscious, the witness awoke to find his father and brother dead beside him. The witness had been shot 7 times. The witness walked about 5 kilometers to his relative's house in Bieline. From there, he was taken by ambulance to a field hospital in Benkovac and later treated at the hospital in Knin. In addition to the persons killed near the house, 6 other Croats were killed in Bruška on the 21st of December 1991, all with the surname of Marinović. The witness learned this at the hospital in Knin from the mother of witness Jasna Denona, née Marinović, who had also survived the attack. In relation to the SAO SPWS, witness Luka Šutalo testified that on the 25th of August 1991, he was imprisoned in the Dalje police station. Šutalo testified about the frequent beatings and transfer of prisoners to and from the prison during the course of his detention. He testified that the majority of the prisoners were ethnic Croats and Hungarians, and one detainee was a Bosniak living in Croatia. Šutalo saw Arkan at the prison on a few occasions. On one occasion, Arkan watched about 3 men in camouflage uniform beat several prisoners with iron chairs until the chairs fell apart. On the 22nd of September 1991, Šutalo was released by Goran Hadžić and 2 other men, all 3 of them wearing camouflage uniforms. One other prisoner, Slavko Palinkaš, was released half an hour after Šutalo. Outside the prison, Šutalo saw Arkan with 30 to 40 men who greeted Hadžić with honors. When Palinkaš returned later that same day with cigarettes for the other prisoners, a policeman told him that no prisoners remained and that they had had their final cigarettes. The next morning, 23rd September 1991, a Croat woman told Šutalo that the other prisoners had been shot about 1 hour after Šutalo's release. The bodies of 11 men who had been detained with Šutalo were found in a mass grave in Celia, near Vinkovci. The chamber also refers to the evidence of witness JF 015 in relation to these killings. In relation to Bosnia and Herzegovina, witness JF 008 testified that on the 2nd of June 1992, he and villagers from Dagalovci were rounded up by Bosnian Serb soldiers and policemen and brought to the district prison in Doboj. In late June 1992, the witness and other detainees were transferred to Perchin's disco in Vila, just outside Doboj. The disco was very near the line of separation with the army of Bosnia and Herzegovina. Between 312 and 320 people, mostly Bosniaks and Croats, were detained in the disco building, which was guarded by policemen from Doboj. While detained at the disco, witness JF008 observed a group of about 20 soldiers wearing camouflage uniforms and red berets provide daily training to about 100 members of local units. On the 12th of July 1992, 3 soldiers in green camouflage uniforms and red berets entered the prison camp and forced approximately 50 of the detainees outside. The witness was not among the detainees forced outside, but he was later told what happened by other detainees who were forced outside. The witness learned that one of the soldiers, wearing a red beret, placed a pistol against the head of detainee Ante Kalem and fatally shot him as a warning to the others. The remaining detainees were brought to the combat line, where they were used as human shields. Many were killed when caught in the crossfire, and only about half returned to Perchin's disco. The chamber also received evidence of the killing of 6 Muslim men in Turnovo in July 1995 by members of the Scorpions unit. The 6 men had been captured in Srebrenica. The chamber refers here to the evidence of witness JF 024 and to exhibit P2161, which is a video showing the 6 men being shot by members of the Scorpions unit. The chamber considers that the evidence before it, including the above examples, addresses all the elements of murder as a violation of the laws or customs of war and murder as a crime against humanity. In particular, the chamber notes that the victims of the crimes described were predominantly of Croat, Bosnian Muslim, and other non-Serb ethnic origin. At this stage, therefore, there is sufficient evidence for counts 2 and 3 to stand. As mentioned, the chamber will later turn to the question of whether there is sufficient evidence with respect to Simatovic's individual responsibility for the crime of murder. In relation to counts 4 and 5, there is evidence of deportation and forcible transfer of Croats, Bosnian Muslims, Bosnian Croats, and other non-Serbs within the SAO Krajina, SAO SBWS, and Bosnia-Herzegovina during the indictment period. For instance, in relation to the SAO Krajina, witness Boško Brkić stated that he was living with his family in Skabrinja when, on the 18th of November 1991, the village was attacked by Serb forces led by the JNA. 8 of the witness's family members died as a result of the attack and the subsequent occupation of the village. The witness described how, on the day of the attack, he and other villagers hid wherever they could find a safe place, and he saw JNA tanks from a distance of about 100 meters. The following night, the witness and approximately 100 villagers fled for Prkos in the municipality of Zadar. by the time he had left the village, the witness heard that some villagers had been executed. Zorka Brkic, the witness's aunt, described to the witness how her husband, son, and daughter-in-law were lined up against the wall and shot by men in JNA uniforms. Although the majority of the villagers had fled Skrbinja, the witness knew of approximately 6 persons who remained there after the 19th of November 1991. These included the witness's elderly parents, who had stayed behind as the witness's father was confined to a wheelchair and unable to leave. They told the witness that every day Chetniks, as it was said, would threaten to kill them. On the 11th of March 1992, the witness's parents were found dead by 2 villagers, who subsequently also fled the village. The witness's parents had been shot. The witness stated that in the month following the attack, the village was looted and burned, and by the 1st of December 1992 it had been completely destroyed. The Chamber has also taken judicial notice of adjudicated facts from the Matic case in relation to, inter alia, intensive shelling of Skrbinja on the morning of the 18th of November 1991. Firing by JNA tanks on private houses, the Church of the Assumption of the Virgin, and the school in Skrbinja. And killings of civilians on the 18th of November 1991 by members of local paramilitary units who participated in the attack on Skrbinja together with other SAO Krajina forces. Witness Slobodan Lazarevic testified that in October or November 1991, the JNA attacked the town of Cetingrad. Lazarevic explained that the JNA had considered 2 options in respect of the attack. The first being to encircle the town and then use saturation bombing in order to, I quote, clean out the city, end of quote. And the other option was to shell the town in such a way as to leave open a corridor through which the villagers could leave. Lazarevic testified that the second option had been accepted. Immediately after the attack had commenced, refugees from Cetingrad started to arrive in Velika Kladuša in Bosnia and Herzegovina.